Good evening, ladies and gentlemen, my friends. This is Dean Joe-Santos Balagtas Bisquera giving you the suggested answers on criminal law in the September 2023 bar examination. Earlier, I uploaded the suggested answers on mercantile law. And I did enjoy giving that, although there were certain moments of emotions as I was making the opening piece of that presentation. This second upload today, which is called Double 10 because it is October 10 and happens to be my birth month. I am sentimental because criminal law, not so many people, is a heavy favorite subject of mine. And there are personal reasons why criminal law is something that I value so much. However, there is one particular name that has been uh, clicking on my mind. And if I believe the concept of astral body, which I do, Noel Innocentes has always been beside me even after he left this world. He died, he passed away, and he is a very special person to me. I met Noel Innocentes when I joined Motorola in the 80s. And we belong to totally different organizations. I came in finance, and I learned he was in one of the more important departments, the department called facilities. And he was the singular person responsible for the entire centralized air conditioning system. And without the air conditioning system running in an electronics company, the units would be affected because of the component of heat. And it is only in that industry, in that organization in Motorola that I learned that you need to balance the temperature in the production line. Otherwise, it affects the quality of the output. Noel Innocentes is the principal player that runs that particular thing. It's a very senior position. He reports directly to the manager of facilities department. I have observed that Noel is one of the three employees, and even if he's a very senior management employee, he has a tendency to be a fiscalizer in some of the employees' get-togethers, and he would ask some of the more difficult questions. And Noel has a personality where if he stands up and starts speaking, he's good-looking, and he has the personality, a commanding personality, that he can sway the bulk of the attendees who are the operators. Because first of all, he's not a rank and file employee; he's a managerial employee, but he can really ask difficult questions whenever issues on personnel policies are brought up. I was surprised that one time he visited my office. Of course, I know him personally, casually, and he said, "Boss, I know that you are first year law, and I've also wanted to take up law." I was shocked because, in my case, law is part of my job, and it is because the issues on finance always intertwines with questions on law. Not to mention, payroll is with me, so I also have a lot of interface with HRD. And so this is the kind of field where when I came to approach HRD, I managed to convince them that my job requires enrollment in law. And so I was given effectively a scholarship where my tuition fee and my books are covered by the company policy on educational support. And Noel was asking me whether there is a chance for him to be also considered because he deals with suppliers, especially uh, those that have something to do with maintenance and air conditioning. And I said, we can try. And so on his first year, he was also able to get into law school, and he was also a Motorola educational beneficiary like me. But somewhere on the second year, I guess I was probably a little more, I can put my weight around because of my level. And really, my job calls for knowledge of the law. And I was never zero in the law because I had a very good orientation in my accounting course. And so to me, a number of law subjects are repetitions for me. And I did really wanted to be a lawyer. But Noel, being a mechanical engineer, is totally new in the field of law. But he said he looked up to me because I was 1 year ahead of him in law school. And there were only the two of us in a population of about 2,000 employees. We were the only two who are enrolled in law school. So Noel is a business associate, kakampi, ka-interact in that semiconductor company, Motorola. And he joined JRU Law. He finished law in just like me, 5 years, and as a working student, and started attending my review classes at the University of Manila. And I was surprised he never immediately ventured into taking the bar. Candidly, he reviewed for 10 years, 10 taon, attending my lectures, and then later on without. Siyempre, sa I accept him libre. But I felt a little betrayed because I later on learned that he enrolled at San Beda in Mendiola, paid his tuition fee. Except that when the lecture has something to do with mercantile law and taxation, he would move out of San Beda to join me and listen to me in UM. And he has been listening to me for 10 years. And I was giving him pointers on how to make it to the bar. He took the bar. Unfortunately, he did not take it on his first attempt. And he was so silent, he did not want to talk to me after he did not make it to the bar. And finally, we were able to reach out to each other. And so in one of the very private moments of sharing, he confessed to me. Sabi niya, boss, pasensya ka na hindi ko pinakinggan yung mga pointers. Medyo mahahaba yung mga sagot ko. And I knew what he was trying to do. He was wanting to also top the bar like me. And it would have been even a miracle because he's an engineer. And if he topped the bar, he would really make a record. Well, it is his ball game. He decided he would do it his way. And so he answered it with kilometric answers according to him. And he didn't pass it. So he said, pakikinggan na kita. Unfortunately, when he was waiting for the next review, the second year after he did not pass the bar, he was killed in the hands of his own cousin in Mandaluyong. They were sharing a big compound belonging to the big family of the INOCENTES. And their door was essentially just probably not exceeding 5 steps. But they grew up together, with the big families, occupying their respective houses inside the compound. But Noel managed to finish the mechanical engineering in Mapua. He was making good. The same with his siblings, and he was moving fast. His house is very visible, improving. But his cousin apparently did not finish, and so this was the sibling rivalry. It's not sibling, but essentially cousin friction that was between them. And that friction came to a head one night when Noel had an earlier visitors who parked their car, which irritated the cousin. Noel parked his car a little distance, but when his visitors left, for some reason, he transferred his car to opposite, just in front of his house. But before he can even drive his car towards the front of his house, his cousin was already waiting for him with a loaded gun with a set of reserve bullets, and approached Noel even before Noel can drive near his house, and pump, I do not know, at least about 8, 12 bullets. I don't even remember. I really did not know what was the gun. It was a handgun. And inubos. Pak, 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 pak. It was about 10, 11 o'clock in the evening. And he was not yet content with killing Noel like on the spot. He went back to his own, front door, and right there, he had another set of bullets. He loaded his gun, came back again, and started shooting Noel. So Noel had no chance of surviving. Surprisingly, for some difficult reasons, when the cousin was walking towards, along the alley towards the main street, and his gun was tucked in front of his belly, the gun started firing, and instantly it also killed him. Very, very strange. When you put your gun right here, how can it fire and kill you? Normally the bullet would only hit the ground. Of course, since I believe in psychic energy, and I believe in astral bodies, and since I know the character of Noel, obviously when he was shot, he was already dead, but his astral body was alive. And by the very nature of his being a fighter, I would like to guess that his astral body ran after the cousin, and he was the one who literally pulled that same gun that hit him. So when during their wake, there were two INOCENTES in two separate funeral parlors that were being served. As a matter of fact, of course, I attended the funeral of Noel, including the actual burial. There were so many people. I was one of them. I could not afford not to be there. And I was very sentimental in saying, Paring Noel, malas naman. Kukuha ka na ng baruli ngayon. Baka lumusot ka na. Makikinig ka na sa akin. And his classmates are there. And they were saying, hindi, may usapan na ho kami. Lahat kami mag-i-enroll sa inyo. Makikinig kami. Si Noel naman. So Noel did not make it to become attorney at law. And because I'm talking about the incident that killed him, I would like to dedicate this discussion on criminal law in the bar examination of 2023 dedicated to him. And I'm sure he's watching, he's smiling, saying that, Boss, maraming salamat, hindi mo pa rin ako nakakalimutan. Hindi, Brad. Hindi kita nakakalimutan. You will always be part of my life. You will always be part of the memories that we shared together. kwentuhan, hindi masyado tungkol sa Motorola. Sawan-sawa na tayo, but in many instances, you and I would be exchanging notes on the various fields of the law. And I think you realize that you looked at me as an elder brother and a more senior law student. And I tried to explain because I have certain advantages being an accounting graduate that you did not have. So, yun nga, ang biro niya, pasensya ka na, hindi raw niya ako sinunod, yung short sentences, direct to the point, nagpaliwanag na siya mahaba. So sabi niya, susunod, susundin na kita. And I wanted to tell him, alam ko gusto mo mag-top sa bar nung kumuha ka. Pag gagayahin mo yung sinasabi ko, siyempre lalabas kaya lang nag-top yan kasi tinuruan ni Bisquera He wanted to do it your way. Kaya nga, magaling kumanta si Noel, and I'm sure one of the songs he used to sing is My Way. Kaya, Brad Noel Innocentes, I dedicate this little sharing with you to allow all of those who are taking law and who will also take the bar and will be watching this version on criminal law to also remember you. And together with Noel, I dedicate this particular portion also to all the bar reviews of UM Law. Yung bar review namin is one of the biggest and the most attended during our time. Saturday, Sunday lang kasi kami. And that's where I started lecturing initially on taxation and then in the subject matter of common carriers, transportation, and insurance. Pero I have never been known to be expert. Marami kasi magagaling sa criminal law during my time. Mga professor ko, mga milestones yan sa criminal law. Si Dean Carling Ortega, si Justice Rodolfo Palatao, pagkatapos nandiyan pa si Attorney Rojas was also my professor in criminal law. Sino pa magagaling dyan? Well, of course, he was not my professor, but we were together in the judicial and the Philippine Judicial Academy. Yung chairman namin sa criminal law at that time, si Justice Edelberto Sandoval. Mga heavyweight yan. Kaya pag tinabi mo sa kanila nung panahon na yun, ay wala, pipitsugin ako. But I was part of the department. So sa kanila, book 1 at book 2, wala, hindi mo sila pwedeng sabayan. Pero once in a while, they'll call me and say, "Hoy, mayroong lecture sa anti-money laundering. Ayaw na yung mag-aral, ikaw na mag-present yan." So, that was how I entered the Philippine Judicial Academy with credentials recognized by the then chairman, the retired Justice Amurfina Melesio Herrera. Pinasok ko kagad noon after my lecture. 100 points daw nakuha ko doon sa mga nakinig sa akin ng anti-money laundering. Kinento ko lang naman yung story ni Al Capone. So without much ado, tuloy na tayo. And dedicated to all of those who were not also lucky. Ilang taon, review sila na review. Parati ko silang kasama sa UN. And nag-refresher sila, nag-estudyante ko. Hindi pa rin pumasa. And many of them, they reached their senior ages and they passed away, but they never became members of the Philippine Bar. I remember one, napakagaling magsalita nung pag nakakorridor magpapaliwanag. Talo kami ng mga professors. His name is Colonel Rose Tamayo. Si Rose, nung minsan binibiro ako, sabi niya, "Dean, bago kahit na 40 years old ka, nung nagsimula ka mag-aral ng law, kumukuha na ako ng bar review, kumukuha na ako ng bar." Sabi niya, "Ngayon lecturer na kita, ikaw na reviewer ko." Ito pa rin ako, nagtsatsaga. And so I finally, became his professor in the refresher course. Sabi ko, "Ross, alam ko problema mo. Number 1, ang sama ng handwriting mo. Pangit na yung handwriting ko, mas pangit pa yung handwriting mo, hindi mabasa. Second, ang haba-haba mo sumagot, paikot-ikot ka. Magaling ka naman magpaliwanag. Pero idiretso mo na yung point mo ganun." And I think he never learned. So I heard, wala na ako sa UM noon at that time. I was temporarily working for the University of Perpetual Health of General and Dr. Antonio Tamayo sa Perpetual Health. Namatay na raw si Rose. There was another lady, old maid na, past 70 na. Tahimik, palagi nag-aaral, hindi nag-a-absent sa review. Pero bagsak ng bagsak. So finally, nung naging student sa refresher, na-discover ko din, ang number one problem is handwriting. So, in pity, because I saw that she was really studying hard. Bakit hindi pumapasa? Ulit-ulit. So, I finally talked to her. No? I miss now her name. And said, alam mo akong problema mo. Alam mo yung batas Tinitingnan ko naman sagot mo. Pero para maintindihan mo yung sagot mo, dapat maintindihan mo yung handwriting. Bakit ba ganyan ka ako ang handwriting mo? May edad ka na Noong generation yung gaganda na handwriting. Sabi niya, sir, tatapatin kita. Dati ako stenographer sa court. Naku, patay ka ako. Kaya ako pumangit din ang sulat because I studied stenography. Mga shortcut. Kaya sa lecture, mabilis ako pero pumangit din ang sulat ko that I have to really practice writing when I was about to take. Sabi ko, mag-practice ka. Kasi tingin ko ako, you have the fundamentals to pass the bar. Pasado lang ako para at least naman sa edad mong yan, parang ako din, ambisyon ko na lang may attorney at law dun sa aking lapida. So, sige sir, we became close. Kahit na old maid siya, balita ko mayaman daw kasi nga matandang dalaga. And tahimik na tao, suplada. Pero we became very good friends. And sabi ko, sige, ready ka na kumuha. Another time, we had a t-shirt uniform nakalagay UM Law. And I required all of my bar candidates to wear that. Sa Lasal pa kami noon. Sa Lasal pa ang bar. And she was wearing that herself. No? At naaawa ako pagka lalabas na yun ng alas 5. Because I told them, huwag na kayong lumabas, magbaon na kayo, doon na kayo kumain sa loob kasi malayo, mapapagod kayo, lalo na. So may baon siya. Pero pagdating ng hapon, lalabas siya, basang-basa. So sabi ko, magpalit ka na nga ako. Kumusta naman? Sir, palagay ko, sabi niya, magiging abogado na. Sige naman ako. At least ka ako, yung hirap mo na ilang taon. Sabi ko, nag-improve naman na handwriting mo. Naku. So she visited me in November. And the bar was supposed to come out din mga March, April. And after she visited me and she gained weight again, okay na siya, masaya na. Naku, nabalitaan ko December, she passed away, namatay. And she promised me that she thinks she will pass the bar. I was about to take a precedent-setting move to ask special permission from the Supreme Court for me to receive her certificate, yung roll of attorneys niya, ako nang pipirma, and I will make representation for humanitarian reasons para naman pagawa ko yung kanyang lapida sa Bulacan na nakalagay na attorney. So I was waiting, December, January, February. Dilabas na yung March result. Tingnan ko si Ross Tamayo, wala. Tapos hinahanap ko siya. And I was expecting her name to come. Wala. So lahat ng plano ko na pupunta ko sa Supreme Court, I was even willing to verbally argue and for me to be allowed as the dean to receive and sign for her. Wala. I dedicate this particular portion to all of you. Tatlo lang yung nababanggit ko ng mga kaibigan ko na very, very special reason. But marami yan. I can't even enumerate them but hindi mauubos ang oras natin dito sa napakagandang discussion ko. So, tuloy na natin mga kaibigan, the suggested answers to the bar examination. I divided the problems into two groupings. The first grouping would be Book 1, the offenses, the persons liable, the penalties under Book 1. And out of the 20 questions, 6 questions came from Book 1, divided among the following topics. Ayan. There was a problem on criminal liability. There was also a problem on persons criminally liable. There was a question on circumstances. There is a question on penalties. And again, related to penalty is the extinction of criminal liability. Itong dalawang ito, normally hindi inaabot ng lecture, but it came up. Okay. And then the second module came from Book 2. Yan. Crimes and Penalties. Nandiyan na, naka-enumerate na. No. And there were, of the 20 questions, 6 came from Book 1, 14 from Book 2. Marami sa Book 2. So medyo talagang, medyo mahirap din. Dahil alam naman nyo na specific ang mga issues on the crimes committed under Book 2. So one question was asked on persons. Another question, 3 questions from property. 2 questions from liberty and security. 3 questions, surprisingly, in chastity. 1 question in honor. 1 question in public interest. And let me bring this back. 2 questions on public order. And finally, 2 questions on national security. Normally, national security inuuna, but because of the normal interest of in watching criminal law, inuna na muna natin yung persons, property, liberty, chastity. Tapos i-ano na natin yung second round. Okay. So these are the 2 major aggruppations of the crimes against persons. Questions on criminal law. 14 of them from Book 2 and 6 of them came from Book 1. Okay. Tingnan ko kung tumatama itong aking chart. Well, dumiretso ka agad dito do sa question, so I should go back to Book 1. Sa chart ng Book 1. So let me now go into the first problem in from Book 1. And this is, the format is, the answers are arranged from question number 1 to question 20. But what I did is when I was able to assemble already all the answers, I started grouping the questions from Book 1. Ito ngayon siya. No? Tigi-tigi sa sila except circumstances dalawa. And so I will discuss them according to the order listed in Book 1. Ganon din sa Book 2, yung setup na yun. So, pupunta tayo ngayon sa criminal liability on the first problem. Okay, tingnan natin. On the issue of criminal liability, the question that was asked runs like this. The question is a little challenging because it asks the question on crimes that are committed outside of the Philippines but under Article 2 are still punishable under Philippine law. And so this was problem number 1. Bukas kagad, problem 1 kagad. Itong tanong. Catalina, a Spanish national, and Conrado, a Filipino, set up a counterfeiting factory in Shenzhen, China. Their factory produces fake United States or US dollars, Japanese yen, and Philippine pesos, which are distributed only in Europe and the US. While vacationing in Panglao, Bohol, they were arrested by a special task force of the National Bureau of Investigation on the strength of a warrant of arrest issued by a Philippine court for counterfeiting and forgery. Both Catalina and Conrado claim that the Philippine court does not have jurisdiction over them since they did not commit any criminal act within the territory of the Philippines. Catalina also argued that the Philippine court does not have jurisdiction over her person as she is a Spanish citizen. Are Catalina and Conrado correct? Nakakapuwing. So let's take a look at our suggested answer. No, Catalina and Conrado are not correct that Philippine courts have no jurisdiction over their criminal act of counterfeiting Philippine pesos in Shenzhen, China, because Philippine courts have jurisdiction under the revised penal code for these kinds of crimes, even if committed outside the Philippines. The revised penal code is enforceable even on crimes committed outside of the Philippines against those who forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government of the Philippines. That is in the revised penal code. Conrado and Catalina are therefore liable for their counterfeiting Philippine pesos in Shenzhen, China. Wala tayong pakialam doon sa pinepeki nila na US dollar at Japanese yen. Pero the moment they play around with our Philippine pesos, then it gets into Article 2, where even if the forgery and counterfeiting is happening outside of the Philippines, it is still, as an exception, covered by Philippine court jurisdiction. Catalina, despite being a Spanish citizen, is liable for committing a crime punishable under Philippine law, because any person who commits a felony incurs criminal liability under Philippine criminal law. Doon mo ginawa yon. Pero ginawa mo yon in violation of Philippine law. But nandito ka, and you are, even if you're a foreigner, you are covered by our law, and you are violating our law. And so you are equally liable to be arrested. Ayan. And we continue, the territoriality principle in relation to Article 14 of the new Civil Code provides that penal laws and those of public security and safety shall be obligatory upon all who live and sojourn, meaning temporarily come to the Philippines in Philippine territory, subject to the principle of public international law and treaty stipulations. Ayun. So, binabanggit na yung Article 14 doon sa New Civil Code, pero ito yung major issue. Articles 2 and Article 4, Paragraph 1 of Book 1 of the Revised Penal Code. And there was a decision of the Supreme Court in the case of Norma A. del Socorro for in behalf of her minor child Rodrigo Norjo van Wilhelm versus Ernst Johann Brickman van Wilsen. GR number 193707, and this is relatively new, December 10, 2014. So liable sila, and because they are in the Philippines, then they are also subject to arrest. That's the first problem on criminal law in the bar exams. Okay, now, ito na ngayon. We are moving now to the second topic that was given in the bar exams. And so we go now to persons criminally liable. Here, the question is something to do with the principal. And the issue is principal by inducement versus principal by direct participation. This is in problem number 5 in the bar exams. And so the question is, Mark was charged with rape as a principal by direct participation. Siya yung tumira. While his employer, Ado, was charged as a principal by inducement for forcing Mark to commit rape by holding him at gunpoint. Mark was acquitted by the trial court for having acted under the compulsion of an irresistible force. Nakatutok eh. Diba? Meanwhile, Ado was convicted of rape. Ado appealed on the ground that he cannot be held liable because there can be no crime if there is no principal by direct participation. Is the argument of Ado tenable? Explain. Ganda ng question. Our suggested answer, Ado's argument is not tenable. There can be a crime committed even when the principal by direct participation is not liable due to justifying or exempting circumstance. So, meron kang principal by direct participation. Meron kang principal by inducement. No? Pagkatapos inutusan ng principal by inducement Tulad nga nito, sige, tirahin mo, nakatuto. So yun, mangyayari, magiging exempting circumstance yun. So, Ado is liable for the rape as principal by inducement, having resorted to an irresistible force for Mark to obey. Mark is not liable for having committed rape, which Ado ordered by way of using a gun to compel Mark to do what Ado unlawfully wanted. No? So, nag-utos si Ado, pinagawa kay Mark, hindi kagustuhan ni Mark. So, merong compulsion. No? And so, here, in the principle of principals by inducement and under justifying circumstance, avoiding a greater injury or evil, mamamatay siya, fulfillment of a duty or exercise of a right or office, and exempting circumstances, imbecile or insane person, person under 9 years of age, person over 9 but under 15 with no discernment, under compulsion of an irresistible force, under impulse of an uncontrollable fear, or equal or greater genuinely. So, exempting circumstances na binanggit natin dito. So, posible na mayroong principal by inducement and principal by direct participation. But the one who participated, sabi niya, wala akong nagawa, tinutukan ako o irresistible force. So, lusot siya under exempting. So, pwede pa rin magkaroon ng conviction yung principal by inducement even if there is absence of conviction on the part of the principal by direct participation. Ang ganda ng problem. Next, after our question on persons criminally liable, let us now go to the criminal law question in Book 1 involving two problems in circumstances. Tingnan natin. In circumstances, we are presented with a very simple problem na sometimes in our rush to review things, minsan maaring na-overlook natin. Yan ang mga delikado. So here is where aggravating circumstance is the problem. And the aggravating circumstance is that the crime was committed in the chief executive's presence. So problem number 4 says, during a concert at night time, held in the cultural center of the Philippines, Chito physically assaulted another attendee, Butch. Chito slapped Butch several times in front of the President of the Philippines, who was also present. Are there any modifying circumstances affecting the criminal liability of Chito? Explain your answer. Yes, Chito committed a criminal offense with the aggravating circumstance of having committed his crime in the presence of the chief executive. It is an aggravating circumstance when an offender commits his crime in the palace of the chief executive or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. So, sampalin mo isang tao, hilahin mo muna, alisin mo sa presence ng executive, o kung nasa Malacanang kayo, lumabas muna kayo. Dito tayo magsampalan sa labas. Okay. So that is how simple the question on aggravating circumstances was given. The second problem that has something to do with circumstances is in the following problem number 12. The aggravating circumstance in murder, which is treachery. One of the 6 qualifying aggravating circumstances in the commission of murder. The problem runs. Timoteo recently lost his job as a security guard at Kabayan Corporation. He blamed his termination on his former co-worker, Tales, because the latter was allegedly bad-mouthing him at their workplace. One day, Timoteo went back to the company premises to retrieve his things. When he saw Tales, a heated exchange ensued between the two. Timoteo then pulled out his gun and shot Tales in the neck. When the latter dropped to the ground, Timoteo approached him, kneeled on top of him, and shot him in the head, instantly killing Tales. Timoteo tried to escape, but his other former co-workers caught him. Timoteo was then charged with murder with treachery as a qualifying circumstance. Is Timoteo guilty of murder? Explain. Our suggested answer, no. Timoteo is not guilty of murder but only homicide. The qualifying circumstance of treachery was absent. Timoteo did not have the time to deliberately employ treachery, a treacherous mode of attack when the shooting was preceded by heated alterations. Yan, napaka-importante. Pag may away na, no, walang traduran kasi nag-aaway na nga, both parties are conditioned already na pwedeng magkasakitan. Now, in the case of treachery, pagte-traitor, dapat yung pinag-iisipan, no? At pinlano talaga na gamitan ng katraidoran or treachery. And the treachery cannot be an aggravating circumstance kung spur of the moment nagbakbakan. Dito makakagulo ng konti kasi tinira niya, bumagsak, walang laban. Tapos pinuntahan pa niya, no? Parang defenseless, no? But and normally ang answer natin yan may treachery, walang laban eh. Pero the more important one that is being emphasized here is that even when there is this kind of sudden attack na walang kalaban-laban, that has to have been planned and thought about, hindi spur of the moment. So ang sagot dito, walang murder qualified by treachery. For treachery to serve as a qualifying aggravating circumstance of murder, the prosecution shall prove A. The employment of means of execution which give the person attack no opportunity to defend or retaliate. Ayan, ganyan nangyari. And normally ito yung natatandaan natin. Pero yung letter B says, the accused deliberately or consciously adopted said means of execution. At pag nag-aaway, walang oras para mag-isip. No? So ano na lang yun, instantaneous. Doon nawawala yung element of treachery. Even if there was the execution did not have the opportunity for the victim to defend himself or to retaliate. Yun ang unang tinitingnan sa treachery. Pero assuming gano'n na nangyari katulad nito, pero hindi naman pinag-isipan talaga na tetraidorin, then there is no aggravating circumstance of a treachery to convert the killing from homicide to murder. And these are the decided cases. Ang pinaka niyan is People of the Philippines versus SPO2 Edgardo Menil e Combit, a 2019 decision. And then People versus Gonzales, a 2000 decision, citing an earlier People versus Manalo decision in 87, further citing People versus De Jesus in 1982, and then People versus Magudato in 1983. Meron pa nakalagay doon, People versus Aquino in the year 2000. Okay. So there is treachery kung walang pagkakataon, pinag-isipan kung paano gagamitin tetraidorin. And so those are the two circumstances that were used from Book 2. And now we go to the next problem, penalties. And the penalties are in the following problem. Reclusion Perpetua. Ito very interesting. Marami nagtatanong dito, even layman. No? Is it a 30-year term or a 40-year term? Okay, let's find out. Problem number 7 reads, Miguel was charged with murder for the death of his neighbor, Nicolas. During trial, the prosecution established that treachery and evident premeditation attended the killing of Nicolas. Hence, the trial court found Miguel guilty as charged and sentenced him to suffer the penalty of reclusion perpetua. Upon the lapse of his 30th year in prison, Miguel filed a petition for writ of habeas corpus on the ground that under the threefold rule, he had served the maximum of his sentence and that his continued imprisonment is a violation of his right to liberty. Will the petition of Miguel prosper? Medyo tight ng konti ito if you did not go through the provisions on penalties. Our suggested answer, Miguel's position may not be tenable because the maximum term for reclusion perpetua is 40 years. Hindi 30 years, 40 years. Which he has not yet served. Hindi pa niya na-serve. No? Yung threefold rule naman does not apply because he's serving only one sentence. Yung threefold rule kasi, kung meron kang 3 penalties, no? Pag napagsalbihan mo na yung kalahati no pinaka-serious penalty, then pwede ka na mag-apply na for you to be released, no? Dahil napagsilbo mo yung pinakamahirap, no, nadadamay na yung dalawang pinaka-maiksi. Kaya threefold rule. Okay. Pero hindi relevant dito kasi isa lang yung crime na ginawa niya, no, which is murder. The penalty of reclusion perpetual shall be from 20 years and 1 day to 40 years. Take note, 20 years and 1 day to 40 years. So, kung hindi mo pa napagsilban yung 40 years, wala, hindi ka pa, you have not completed your penalty. So, any person sentenced to any of the perpetual penalties shall be pardoned after undergoing the penalty for 30 years. Dito nang galing. Kung naka 30 years ka na, no, perpetual penalty yun, pwede kang ma-pardon. Yan, pardon yun. Unless such person, by reason of his conduct or some other serious cause, shall be considered by the Chief Executive as unworthy of pardon. So, papasok ngayon na merong motion, no, from the Bureau of Corrections for the President of the Philippines to approve pardon dahil naka 30 years na. Pero pwedeng tanggihan, yes. Kasi ang maximum penalty is 40 years. 40 years, hindi na pwedeng tanggihan, na-serve na. Pero kung 30 years hindi pa na-serve, no, there will now be pardon only if there is good conduct inside. Kaya kailangan magpakabait din. At nasa loob. Okay? So, yun ang pagsisisi. Yung sinasabi natin na classical theory in Book 1. Okay. And that is, of course, covered by, Article 27 and Article 70 on the revised penal code. So, yun ang duration ng reclusion perpetua. Ito, importante kasi mga lima nagtatanong, sir, 30 years na yun maximum penalty ng reclusion perpetua. Ang sagot mo, hindi. Kaya sinasabi, kaya ang reclusion perpetua for life, hindi naman for life. Usually, yung life imprisonment, nasa mga special laws yun . Pero kapag ka-revised penal code, ang pinakamabigat, reclusion perpetua or death. Diba? Ngayon, ang reclusion perpetua, hindi 30 years, 40 years. Pero kung nakaserve ka ng 30 years at good moral character ka, ang basihan mo nang lumaya ka under reclusion perpetua is number 1, naka 30 years ka. Number 2, good conduct ka. Number 3, inirecommend ka. Number 4, inapprove ng presidente. Yun, lalaya ka after a 30-year service of your reclusion perpetua penalty. So, yun ang penalties. No? Medyo hindi madali. Kailangan alam mo talaga, dapat na pag-aralan mo. So, na extinction of criminal liability. The last problem under Book 1 in criminal law. Here, let's take a look. It says, presidential pardon, election for public office. Ito, napaka-complicated. No? Now, number 6 problem says, Pido, a private contractor, was convicted of plunder in conspiracy with certain government officials. He was sentenced by the Sandigan Bayan to serve the penalty of reclusion perpetua. Ito na naman, yung 30 years pardon or 40 years na maximum service. Years later, his childhood friend Benjamin was appointed as Secretary of Justice and was able to convince the President to grant Pido a presidential pardon. Both the judgment of conviction and the presidential pardon were silent as to the accessory penalties. Now a free man, Pido decided to give back to the community by running for public office as mayor of his hometown in Bulacan. The incumbent mayor sought your advice if he can challenge the candidacy of Pido. On what grounds can the incumbent mayor challenge the candidacy of Pido? Discuss. The incumbent mayor may challenge Pido's candidacy in that his presidential pardon did not include pardon for perpetual absolute disqualification, which the offender shall suffer even though pardon as to the principal penalty. So pag binigyan ka ng presidential pardon, dapat mabanggit that the pardon will include, pardon on the perpetual absolute disqualification. If that was not mentioned, then there will be an issue on whether or not that the disqualification will not prevent him from running for public office. The revised penal code provides that the penalties of reclusion perpetua and reclusion temporal shall carry with them that of civil interdiction for life or during the period of the sentence as the case may be, and that of perpetual absolute disqualification which the offender shall suffer even though pardon as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Sabi mo sa Presidente, to the Secretary of Justice, Sir, isama niyo na lahat ang absolute pardon for everything. Yan, lulusot ka na. And then the revised penal code further provided that a pardon shall not work the restoration of the right to hold public office or the right of suffrage unless such rights be expressly restored by the terms of the pardon. So, strictly construed, dapat binanggit yung subsidiary penalty na right to hold office, meaning to run for public office, and also the right to vote. Dapat yun nasama yun sa pardon. Kung hindi, disqualified ka. No? Continuing now, it says, the local government code disqualified to run for any elective local position those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more of imprisonment within 2 years after serving sentence. But the Supreme Court ruled that a pardon, being a presidential prerogative, should not be circumscribed by legislative action. So dito, ang nagsabi rito, Congress to the local government code. But the Supreme Court, in the case of, what we call this, ang cited case dito si ERAP, na kinasuhan ni Attorney Alicia Rizos Vidal and Mayor Lim. Magkalaban sila ng pagtakbo sa Mayor of Manila in 2015. Ang sabi dito, finally, the reckoning point will be, the Supreme Court said that when there is pardon being a prerogative, it cannot be limited by legislative action. So dito, itong provision na ito will not work. No? Now, if this will not work, the question on kung hindi nasama yung pardon, pwede bang i-assume na doon sa pardon yung right to be to hold office and the right to run for public office. No? And apparently the sentiment of the Supreme Court is that pag tinatawad na ng presidente yan, consider na natin absolute pardon. Yan ang sinasabi. Okay? And therefore, if there is another similar ERAP Estrada versus Alfredo Lim, at meron na namang na-convict, it will be a very good test case to see na yung disqualification will now be following the decision of the Supreme Court in the case of Alicia Rizos Vidal versus Joseph Ejercito Estrada. And so, that particular thing, my dear friends, completes the 6 problems given in Book 1. And so, we are now ready to go to Book 2. Book 2 speaks about the crimes and penalties, and there were 14 problems given under Book 2. The first problem has something to do with persons. Oops, sorry. nawala yung ating ito maganda pag alam mo yung ikaw gumawa, alam mo rin kung saan mo pipitikin. Ayan, para makabalik. Masyado napabilis yung ating play. So, under Book 2 on Crimes and Penalties, the 14 questions that were asked would be something like this. Okay? Isa tanong sa persons, 3 tanong sa property, 2 tanong sa liberty and security, 3 tanong sa chastity, 1 tanong sa honor, 1 tanong sa public interest, 2 tanong sa public order, at 1 tanong sa 2 tanong sa national security. Let's take a look at the question concerning persons. On the crimes against persons, the subject matter was actually, ayun nakalagay, is homicide under exceptional circumstances. And ito pumasok ngayon yung very interesting, favorite natin, yung mistake of fact. No? Remember, yung mistake of fact. Ang classical decision dito is of course the Achong case, di ba? Natatandaan niyo yung Achong, yung kasama niya lumabas, ngayon natatakot siya at may nababalita na may pumapasok doon sa mga quarters na yun. Which is year 1910, dyan sa Fort Bonifacio nangyari. Marami pang kalahiban doon. Hindi pa kanina na yun. So, natakot si Achong, yung niya, yung pinto, nilagyan niya ng harang na, siguro hindi secure yung lock, nilagyan ng harang na silya. So, nung kumatok, sabi niya, sino yan? Hindi sumagot. Tapos naitulak yung pinto, binanatan niya, patay. Nung pala yung sinisita niyang papasok, yung pala yung kasama niya na talagang dapat dito niya. Napatay niya. Pero sabi ng Supreme Court, kung hindi nga yun, yun ang kaibigan niya, in his mind, yun yung papasukin siya, makapatayin siya. And in the exercise of self-defense, dahil pinwersa na, natamaan pa siya nung nakaharang na silya, sinaksak niya. So, kung tama yung iniisip niya, lusot siya under the concept of self-defense. Tingnan natin ngayon itong problem number 2, how it worked. Napakaganda. When Joey came home from work, he saw a man and a woman making love in the main bedroom. Enraged at the thought that his wife, Abby, was unfaithful to him, he shot the man and woman to death. However, the couple turned out to be the driver and kasambahay. The families of the decedents filed the case of double homicide against Joey. Joey invoked the defense of mistake of fact, arguing that he thought the persons he shot were his wife and her lover. Thus, he is entitled to the privilege or benefit of Article 247 of the Revised Penal Code, which entitles a legally married person who, having surprised his or his spouse in the act of sexual intercourse, kills or seriously injures the same, to the penalty of destierro for being an exceptional circumstance. Is Joey correct in invoking the defense of mistake of fact? Discuss. Our suggested answer. Ito medyo matindi. Our answer is no. Joey is not correct in mistake of fact as a defense. He had the opportunity to identify the man and the woman making love, but he did not verify before shooting them without any hazard to himself. He is liable for double homicide. Okay. So, nagyayarian na ganon, inabutan niya. Okay. Wala namang danger sa kanya eh. Oh, at may oras pa siya. Hoy, mga putang ina nyo, nagyayarian kayo dyan, papatayin ko kayo, bumangon kayo dyan. Oh, syempre, pagka nahuling ka nun, papalag na yung yung lalaki. Oh, ayun, puto ka na niya. Di ba? Dahil nakilala, lalaki nga ito. Ganun. Nangyari, hindi niya tinanong, sino ba kayo? Basta tinutukan na lang niya. So, he had the opportunity to verify kung yung asawa niya at saka ibang lalaki nagyayarian. He did not use the opportunity, therefore, he does not benefit from mistake of fact because the mistake could have been verified. Yung kay Achong, hindi, binerify nga niya eh. Sino ka ba? Pag ka papasok dito, papatayin kita. Hindi sumagot at tinulak pa. So that already gave Achong took the opportunity to check. Dito sa problem na to kay Joey, he never even explored the opportunity to understand. Asawa ko nga ba yan? No? Pwede naman split second. Hoy, ba't mo tinitira yung asawa ko? Pagka pumalag na, may threat na sa'yo, pak, pak, pak. Hindi. Mga walang hiya kayo, nagyayarihan kayo, pak, pak, pak. Hindi pala yun ang asawa niya. It is not a mistake of fact. Death under exceptional circumstances is occasioned with enormous provocation and indignation. Yun ang justification kung bakit mo papuputukan. The accused would act in a burst of passion. Galit na galit ka. No? Pero kahit na galit ka, and that is an act of provocation yung sa honor mo, no? Sa iyong pagiging asawa, it does not remove the opportunity na mawalang hiya kayo, nagyayarian kayo, di ba? And on the basis of that, medyo magugulat yun na tatayo. Pag tumayo, hindi pala yun ang asawa niya, hindi din yung hindi naman yung lalaki nga yun, pero yung nakikipagyarian, hindi asawa niya, yung katulong. So, hindi niya puputukan niya dahil di naman niya asawa yung katulong. Okay, biruan dyan. Paano yung katulong? For example, niyayaring dyan, kabit din niya. No? Wala na, kasi dapat yun legally married. Okay, hindi kasamang common law. The accused may not have the opportunity to validate the facts of infidelity to lead him to take immediate action that would justify the killing. Dapat walang opportunity, lalo na may danger pa. Kung na baka balikan siya, di ba? Pero kung nakikita man, wala. Sindihan yung ilaw, di ba? That's an opportunity. And so, Achong exercised the opportunity to verify the intruder before he undertook to kill him in Achong's self-defense. Yun. Pinakita na yung kaso ni Achong, clarified yun na he tried to verify. No? At that is a very important component, kaya naging mistake of fact yung kay Achong. Kala natin, basta nagkamali ng iniisip, titira na, excuse. Hindi. Dapat, bigyan mo ng opportunity. At yun ang magko-confirm ng mistake of fact dahil hindi ka binigyan, tinek mo, hindi talaga ma-check. So, may danger ka na sa sarili mo. Doon papasok yung meron ng danger sa sarili mo. Then, in the act of self-defense, tirahin mo na. The Supreme Court did not allow mistake of fact as an excuse for the arresting officers to shoot and kill a wanted escapee who was asleep when about to be arrested. Said officers had the time and opportunity to determine the suspect's identity without hazard to themselves. Mistake of fact was not accepted for the killing of the wrong person. Our rationale in getting the opportunity to verify kung asawa niya o hindi came from a similar mistake of fact defense. May dalawang pulis, no? Meron silang mission to arrest and escape criminal. No? Nasundan nila, nung pasukin nila yung supposedly yung place na sa nagtatago, pagbukas nila ng pinto, natutulog pala yung aarestuhin. And because he is a confirmed reckless criminal, pinutukan nila kagad. Yung pinutukan nila, nagkamali pala, kamukha lang yung So, they are guilty of homicide. Meron pang treachery yun. Walang kalaban-laban. Di ba? Pinutukan nila. Ang sinasabi ng Supreme Court dito, this is the case of People versus Antonio Uwanis and Alberto Galanta. A 1943 decision. No? Si Achong 1910 Ito later, 1943. Minodify ng Supreme Court. Hindi nyo naman dapat pinatukong kagad. Okay nga, wanted criminal yon, baka lumaban yon. Pero sana sinindihan nyo yung ilaw o chinek nyo, hoy, ikaw ba si Asyong Salonga, for example. Tapos biglang gumising, bubunot ng baril. Ayun, putukan mo na. Pero kung for example, nagising, number one, siya si Asyong Salonga na hinahanap. Pero wala namang means na atake, di hulihin mo na, nakatutok yung isa, lagyan mo na ng posas. Pero pag sindi ng ilaw, hindi pala siya si Asyong. Sabi mo, ikaw ba si Asyong? Hindi po ako. Ako po si Tembong. Ayun. Hindi mo na pwedeng putukan. Arrestuhin mo na lang. Sabihin mo, ikaw nasundan namin. We will see if you are not really the accused person. Okay? Napakagandang case ito sa mistake of fact. It is a modification of the Achong case. No? Kaya ngayon, nagbago ng konti yung Achong. Dapat may opportunity to verify. Okay. So that's the crimes against persons. Now, punta tayo sa crimes against property. There were 3 problems under property. Ang ganda, no? Ang mga problems sa criminal law. The first problem under property has something to do with theft. Ito napakaganda na naman. No? And I will explain why. Yung concept of finder-in-law has been introduced by the Supreme Court in the decision that is relevant. Problem number 19 reads, before Millet drove to the public market one Sunday, she organized her money by bundling together her dollars worth $4,000 and placed $20,000 in an envelope. She drove to the market, bought shrimps and oysters, then hurried back home to prepare lunch. While she was unloading the food from her car, the bundled $4,000 unknowingly fell from her bag and rolled over to the sidewalk. At that moment, a lato-lato owned by 13-year-old Henry suddenly flew near the car of Millet. When Henry retrieved his lato-lato, he saw the bundled money and secretly picked it up. On his way home, Henry bumped into their gardener, Junie, who saw him carrying the bundled money and grabbed it from him. After hearing where Henry got the money from, Junie took 2,000 of the 4,000 as his balato. Junie immediately exchanged the money to Philippine currency and brought an Omega X Swatch, Moon Swatch, a Gucci belt, and the latest Samsung phone. Junie was later arrested and charged with theft. Junie argued that he could not be liable since he was not the one who found the money. Is Junie correct? Very interesting. Ikaw, nanakaw mo yan, nanakaw mo lang yan. Hati tayo. Hinuli siya ngayon. Hindi naman ako kumuha niyan eh. Kinuha ko sa magnanakaw, hindi ako magnanakaw siya. Okay. Now, ito na ngayon ang sagot ng Supreme Court. Junie is not correct. Even when he was not the one who found the money, he is what is called now finder-in-law. Bago yan, finder-in-law. Junie knew Henry secretly picked up the money which belongs to Millet. Instead of returning Millet's money, siyempre, nakaw yun. Ninakaw pa niya. Dapat isoli niya. Junie took said money instead. Junie placed himself as if he was the actual finder. When he got the portion of 2,000, he already made himself look like the actual finder-in-law. He now is the finder-in-law, and in fact, his taking the money made him equally liable as if he himself found the money. Yan, ganda niyan ha. So, may nagnakaw. Nagnakaw ka, hati tayo dyan. Okay. Pag nahuli ka, hindi naman ako nagnakaw eh. Siya ang dumampot. Sabi na ngayon ng bagong batas, hindi. Dahil siya nga nakakuha. Kinuha mo naman yung portion, kasama ka din. Na para ikaw din ang nakakita ng portion ng 2,000. The explanation of the law in the case of Fernando Pante versus Rangasa versus People, a 2021 decision. It says, the finder-in-law concept is to protect the owner when the stolen property is transferred from one individual to another. Yan. Batang Quiapo, yung nangyayari sa Quiapo, di ba? Dudukutan ka, hahabulin mo yon, ipapasa ka agad doon sa iba, pasa-pasa, siguro mga 7, 8 hanggang 9 yun. Grupo yun. By the time na nahuli mo, itong nagnakaw, ikaw ang pulis, nahuli mo kasama yung biktima. Yan ho nanghuli sa akin eh. Yan ho nagdukot sa akin eh. Hindi ako nagnakaw. Sabi, hindi ako nagdukot sa inyo. Kung kayo magbibintang ng ganyan, di ba? Oo. Hindi kakapkapan. Di ba? Dahil ito hot pursuit operation. Ikaw, hinuhuli ka namin dahil theft ka. Kinapkapan. O tinan nyo, wala sa akin. Di sasabihin, hindi ko pinasa uro sa hanap na naman. Wala na naman. Ultimately, may nagbulong-bulong tip sa pulis. Alam mo na may mga pulis, malakas din ang connection. Kilala rin nila yung mga magnanakaw. Nahuli ngayon kay Tembong. Hawak-hawak ni Tembong yung wallet at yung pera. Ngayon sabi, o Tembong, ikaw pala magnanakaw. Hindi ho ako. Naipasa lang ho sa akin ito. So hindi ho ako nagnakaw nito. Napasa lang ako. If you accept that as the defense, then matutuloy ngayon na pasapasahan lang, makakalibre. Ang sabi ngayon ng batas under the Fernando Pante case, kapag ka ikaw, nakuha mo yung portion na ninakaw o yung mismong yon, parang ikaw din yung nagnakaw and you are now called a finder in law. Yun, finder in law. Pag hindi mo inadapt yung concept na yan, magpapasapasahan lang yan. Walang masisintensyahan. No? So, the teamwork of passing the stolen money, the stolen commodity, from one person to another, will now be a shield to protect the criminal offense. Ngayon, under this kahit kaninong mapunta yun, kasama ka, parang ikaw din ang nagnakaw. Very, very beautiful. And whoever made this decision was very good. The judge who made this decision and then the one that was reviewed it in the Court of Appeals and the Supreme Court. At napakagaling yung examiner na nagsama nito. Because without including this in the 2023 bar examination, I will have no opportunity to emphasize to you this again, another angle para rin yung kaninang mistake ko pa. Kaya, I congratulate the examiner who included this because it allowed us to understand the concept of finder in law under the tech provision. Now, the second problem under property is swindling or estafa versus malversation. Ito, I was not very comfortable in facing this issue. Ito isa sa mga hinuli ko. But I am taking a position, and it is like this. Problem number 18. Metropolitan Waterworks Sewerage System, MWSS. Employee, Japar was often assigned to do field work. Every time he does field work, he accomplishes a disbursement voucher for the amount he needs and liquidates the voucher by submitting receipts to the MWSS cashier Philippine. At the end of the day, one day, another MWSS employee, Jonas, desperately needed 230,000. Taking the same disbursement voucher that Japar habitually signs in the morning, Jonas filled it out with the amount that he needed. He then forged the signature of Japar before presenting it to Filomena, who in turn released the stated amount. After some time, Filomena noticed that the voucher remained unliquidated. When Filomena showed the voucher to Japar, the latter swiftly returned it, telling Filomena that the signature appearing in the voucher was not his. Filomena then realized that Jonas was the one who presented the voucher and took the money. When confronted, Jonas readily admitted to the act. He was eventually convicted of malversation. Was the conviction of Jonas proper? Explained. The two issues that bothered me is that is MWSS a government entity? And second, is the money that was taken from a government entity made by someone who had the opportunity to take that money when it was, he had the responsibility to take care of that money. Yan ang concept ng malversation. Ikaw ang pinagkatiwalaan ng pera, ginalaw mo yung pera. But in this particular problem, hindi naman si Jonas ang accountable ng pera, yung cashier. Ito si Filomena. Siya yun. So kung siyang gumamit nun, yan ang malversation. Pero kung kinuha ni Jonas yun from her, then that is not malversation. Okay, so tingnan natin ang suggested answer. No, Jonas' conviction of malversation is not proper. He committed the complex crime of swindling, fraud, or estafa through the falsification of private document. We are assuming here that this voucher is not a public document. It's supposed to be used within the system of accounting system of MWSS. So Jonas is not a public officer accountable for public funds. No, wala siyang hawak ng public funds, which he misappropriated. No, he was not in that position. Ang may hawak ng pera dito na government official or government employee is si Philomena. And definitely, Jonas is not in that kind of position. So, he never committed malversation because he was not accountable for the money that he took. And so, continuing, Jonas is not a public officer whose official duties make him accountable for public funds which appropriate such funds. Through fraud done with a falsified disbursement voucher, Jonas encashed the voucher and accordingly took away MWSS funds for himself. And so dito ngayon, dito ang reason why our suggested answer is when he took the money from MWSS, that is essentially through fraud, panluloko, pinalabas niya na siya si Japar. And therefore, entitled siya na gawin itong cash advance na ito. And therefore, nung kinuha niya yung pera ng MWSS through fraud, panloloko. And yung panloloko niya is pineki niya yung signature ni Japar. So, he essentially committed fraud through falsification of a disbursement voucher, which is supposed to be a private document. Private document. Hindi, accounting form yun. Hindi naman hindi naman pareho yung mga dokumento na ninonotarize. So here, the recommendation is that Jonas is not to be convicted of malversation, but a complex crime of fraud or swindling or stapa to the use of falsified private document. Medyo nag-isip ako ng konti, but I would stand pat that medyo malayo yung problem, malversation. So, kung tendency mo yes or no lang. No, hindi mo malalaman kung bakit no unless makikita mo na lokohan. And so therefore, kung lokohan ang pagkuha ng pera, swindling. Kasi tatlo lang ang mekanismo nun eh. Either kinuha mo, walang permission, theft. Kinuha mo, may force, robbery. Pero kung walang force, no, paano mo nakuha? Binigay sa'yo. Ba't binigay sa'yo? Kasi naloko mo. To the voucher. So, yun malabas. Swindling yung fraud yun. The third problem on property, it has something to do with malicious mischief. Ito medyo nakakapuwing itong question. Problem number 11. Out of their miserable feeling that they're starving, nagugutom, while the wealthy people in Mayaman Hills subdivision are practically throwing away their food, riding in expensive cars, and living in extravagance. Primo, Victor, and Maximo marched to said subdivision and stoned the house there as an act of hate against the rich. With what crime, if any, should the apprehending officer charge Primo, Victor, and Maximo? Now, this is a very, to me, nakakapuwing na question. And so that therefore, let's take a look at our recommended answer. Primo, Victor, and Maximo committed no offense in the revised penal code when they stoned houses where no house was damaged. Wala naman sinasabing nag-ano dito may nasira Malicious mischief is committed as a criminal offense against property only when there is damage arising from said stoning. There is no damage indicated in the case. So, no offense. Binati mo Okay. Ngayon, kung ano yan, malicious mischief yan, no, dapat may nasira. Diba? Binato mo ng eba, maaaring hindi nga nasira, pero bumaho naman yung pambubwisit. Pwede sigurong unjust vexation. Ito, tingin ko dito, maaaring may element ng unjust vexation kung may nagreklamo na nabwisit siya. Pero wala naman nagre-reklamo din, kaya wala rin yung unjust vexation. Wala nabwisit. Siguro binato nila, hindi naman narinig kasi makakapal yun. So there is no offense. My answer here. Malicious mischief is an offense where a person shall deliberately cause to the property of another any damage not consisting of arson or other crimes involving destruction. There is no unjust vexation, nabanggit ko rin yan, or light coercion. Violence is employed in coercion to prevent another to do something not prohibited by law or compel someone to do something against his will, whether right or wrong. This stoning was not done to prevent or compel anyone to do something. Wala eh. Oo. Like coercion or unjust vexation. Okay. So hindi rin uubra dahil wala nga namang pinagawa sa kanila. There is no breach of peace. O baka naman breach of peace, sabi ng police. Ito, local law ito. As the case did not indicate that anyone from the subdivision complained that the stoning caused any disturbance at all. Kung wala nagreklamo, walang kaso, di ba, no? So, sabihin, breach of peace under the local ordinance, wala naman nagreklamo. No? So, this is pursuant to Articles 327, 328, and 329 under Chapter 9 of the Revised Penal Code on Malicious Mischief on Property. And then Article 287 of the Revised Penal Code on Unjust Vexation, light coercion, threats, and liberty of security. Again, wala eh. Walang na ito sabi nga eh, sa unjust vexation, wala naman na puwersa. Okay. And if you find out, if you try to pursue the concept of breach of peace, you will have to go to Section 844 of the City of Manila's Ordinance. So this has to have happened in Manila for you to even invoke that. But in this particular case, sabi ng case of Minda Clemente Ideas versus People, that if there is no complaint of the stoning that disturbed anyone, wala ring breach of peace. So that is the, medyo ito nakakapuwing. Kasi look at my suggested answer is no offense. Sino ba naman sa bar magbibigay ng sagot na no offense? Hahanapan ng butas yan. Ang probability niya lalagay pambubuisit, unjust vexation. Kung magaling, nasasabing malicious mischief, walang nasira. So mangyayari sa unjust vexation, nambuisit. Pero sa nambuisit, ang kailangan merong there is compulsion using force to force a person to do something, to compel him to do something, or to prevent him from doing something that is legal. Wala naman eh. Okay. So, no offense. So, that would now cover our crimes against property. And so, we are now ready to move on to the two crimes given, or two problems given on liberty and security. The first problem under liberty and security runs like this. Special complex crime of kidnapping for ransom with homicide. Problem number 3. Doming, in conspiracy with Dado and Dario, kidnapped and detained 9-year-old Rosana. They demanded 2 million as ransom money from the family of Rosana in exchange for her life and liberty, which the family agreed to pay. However, Doming, Dado, and Dario killed Rosana while she was in captivity. What crime, if any, did Doming, Dado, and Dario commit? Discuss your answer. This is our recommended or suggested answer. Doming, Dado, and Dario committed the special complex crime of kidnapping for ransom with homicide. Where the person kidnapped is killed in the course of the detention, regardless of whether the killing was purposefully sought or was merely an afterthought, the kidnapping and murder or homicide can no longer be complex under Article 48. Kasi dati, nangyayari, pag kinidnap, edi one criminal offense yun. Pag pinatay, another criminal offense, no? So sasabihin mo, complex crime yan under Article 48. Now, under the new rules now, it says, they cannot also be treated as separate crimes, but shall be punished as a special complex crime under the last paragraph of Article 267 on heinous crimes as amended by Article number 6959. Naging simple. Pag kinidnap yung may kidnapping victim, whether kasama yung pagpatay sa plano or basta nakasunodaan lang patayin, there will only be one simple complex crime of kidnapping for ransom with homicide. Wala nang analysis ng separate crime. Ito nangyari, incident, i-complex natin. Actually, dati compound crime. Ngayon hindi, simple complex crime na binigyan na ng pangalan, and therefore it becomes easy to prosecute. Hindi mo na iisipin kung yung bang pagpatay pinag-isipan pa nakasama sa kidnapping o yung ba nakursunadahan na lang din. Becomes irrelevant na. Basta may napatay, ang kaso would be kidnapping for ransom with homicide, a special complex crime. So bago ito. The next question on liberty and security runs like this. Ito coercion. Ito pumapasok na ngayon, pinag-usapan natin, yung light coercion, which is also unjust vexation. No? Pambubuisit to prevent you from doing something that you are entitled to do, or forcing you to do something that you are not supposed to do. It's not legally to do. So number 16, Socorro owns and leases an apartment building where Ramil is one of the tenants under a 2-year lease. The first year went by with no issue as Ramil paid his rent on time, if not earlier. However, when he lost his job after the pandemic, Ramil failed to pay his rent beginning the 3rd month of the 2nd year of the lease. Socorro repeatedly demanded payment from him but to no avail. Thus, she filed the case of ejectment against Ramil. When Ramil received the summons, he locked himself in the apartment unit. Tinago niya. Kaya papasok dito. This infuriated Socorro so much so that she padlocked the apartment unit and cut off his utilities when Rami momentarily left to go to the supermarket. No? Kasi kung nilock niya yun, no, magkakaroon ngayon ng parang unlawful, parang kinulong mo, di ba? Pero pinalabas mo na into problem yung tao, tapos tsaka niya kinandado o tinutulan niya ng kuryente at tubig. What crime, if any, did Socorro commit? Normally, alam natin na pag binigyan ka ng inyong problem, you normally think about qualified trespass to dwelling. Kasi yung lessor, yung nagpapaupa na may-ari, papasukin yung bahay. And even if merong palya na yung you have to have court action. Kaya may kaso ng unlawful detainer. Para may court order, then makakapasok ka na. Pag pumasok ka, violation yun. Kasi dwelling yun . O kahit napasa na yung iba yung kaso ng hindi siya nagbabayad, civil action lang yun. Pero pasukin mo siya, criminal action, qualified trespass to dwelling. So tingnan natin ang suggested answer natin. Socorro committed the offense of light coercion or unjust vexation. Her having padlocked the apartment and cut off its utilities would comprise human conduct which, although not productive of some physical or mental harm, kasi nakalabas na siya could unjustifiably annoy, yung pambubuisit, or vex an innocent person like Lessee Ramil. Yan. And there is a decision of the Supreme Court in 2011 involving Joseph Anthony Alejandro. I was surprised here, the name of Firdausi Abbas is included here, no? And they were supposed to be the ones renting the place, no, that is being leased out by Attorney Jose A. Bernas. Yan ang ginawa. So ang kaso doon is unjust vexation, pambubuisit. O kaya ngayon, unjustifiably annoy or vex an innocent person. O, hindi ba pambubuisit yun? Annoy. So that is the problem given under the topic of liberty and security, and they were very interesting questions. Now, ito interesting. Three offenses against chastity, and we go through those problems now. The first problem under chastity runs like this. Under the concept of abduction and grave coercion, a compound complex crimes. Problem number 17 says, Police Colonel Wally had been courting Delia for more than 1 year. One day, he invited Delia for some coffee and snacks, which she accepted. Wally arrived in their agreed meeting place, and once there, he escorted Delia inside his car. Instead of going to a nearby coffee shop, he drove to Lipa City, Batangas, and forcibly detained Delia in a secluded resort against her will, preventing her from leaving until she agreed to marry him. Days after, Delia relented, and Pastor Tiburcio solemnized the wedding. Visibly disturbed by the profuse crying of Delia, Pastor Tiburcio reported the matter to the authorities. What crime, if any, is Wally liable for? Explain. Let us take a look at our suggested answer. Wally is liable for abduction. Kinuha niya. When he drove Delia and forcibly detained her against her will. Wally committed a second offense, grave coercion, when he compelled Delia to marry him against her will. The abduction of any woman against her will and with lewd design shall be punished by reclusion temporal. For that. Normally, kadugtong nun, pagka inabduct mo, re-rapin mo. Pero dito, hindi niya ni-rape. So, abduction lang. No? Walang with rape. Abduction, pero may kadugtong na grave coercion dahil pinilit yan, pakasalan siya. Okay. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who without authority of law shall by means of violence prevent another from doing something not prohibited by law or compel him to do something against his will, whether it be right or wrong. Yung pinilit na pakasalan, no, kahit na hindi issue na right or wrong yun, she was being compelled to do something against her will. So, abduction and grave coercion. Okay. Next question, under chastity. Statutory rape, sexual assault. Ito medyo mahirap. And it made me think. But if you look at the provisions of the law, mahuhuli mo na madali yung kaso. Madaling i-diagnose. So problem number 15 says, Linceo and Adolfo work for the same employer who allowed them to reside in a compound in Pasay City. While Florida, the 7-year-old daughter of Linceo, was playing with 5 other friends on a bulldozer parked near the compound, Adolfo, who was working nearby, chased the children in anger and told them to climb down the bulldozer. Except for Florida, all the other children quickly complied and left. Eventually, Florida went down and sat on the nearby pile of coconut lumber. Adolfo then approached Florida and poked a welding rod into her genital area. Florida cried in pain and saw her vagina bleeding. What crime, if any, should Adolfo be charged with? Explain your answer. I would consider this a little tough. And let us see what is our suggested answer. Adolfo should be charged with statutory rape by sexual assault in relation to the special protection of children against child abuse, exploitation, and discrimination. So, statutory rape. No? Kasi ito, ang bata, 7 years old. No? Tapos, ginamitan pa ng rod. So, merong sexual assault. Okay, let us find out why is that so. Clarida, as the victim, is a female child under 12 years old, on whose genitals the accused inserted a welding rod, a criminal act being statutory rape by sexual assault. Kasi kung hindi ginamitan, kung ginamitan ng human organ, then it will be statutory rape. Period. Pero kung ang ginamit pantusok, sexual assault yun. No? Statutory rape pa rin because it was her genitals that was attacked and she is 12 years old. Frerida was subjected to assault comprising child abuse because she was 7 years old with Adolfo poking a welding rod into her genitals. And this is, if you notice, a celebrated case, People versus Flor Puello. Siya yung silin sa'yo, yung Puello, alias Tito Flor. 2020 decision. So, statutory rape with sexual assault. No? Yung object rape na sexual assault ngayon. The third problem under chastity is to do with corruption of minors. Statutory rape pa rin. Problem number 13 reads, Rita asked Belen, a 14-year-old girl, to meet with her at Duo Mart supermarket for an errand. Upon meeting at the supermarket, however, Rita brought Belen to the nearby hotel and met Elmer. Rita left the other two in the room, where Elmer had carnal knowledge of Belen. When Rita returned, Elmer paid her 2,200, of which 700 was then given to Belen. Rita warned Belen not to tell anyone about what happened. Before they could all leave the hotel room, the police barged in and arrested Elmer and Rita. During the investigation, Rita argued that she did not force Belen to have sex with Elmer for a fee. Belen herself admitted that she consented to have sexual intercourse with Elmer. What crime, if any, is Rita liable for? Explain. Our suggested answer. Rita is liable for corruption of minor girl Belen. Rita abused the confidence that Belen reposed on her, brought the minor girl to have sexual intercourse with Elmer for a fee of 2,200. Rita is a person who abused the confidence on her, meaning on Belen, facilitated the prostitution or corruption of a 15-year-old girl, Belen, no? Dito 14 dito sa problem, to satisfy the lust of another person, Elmer, for money or for profit. This is under Article 340 of the Revised Penal Code on corruption of minors, seduction, and corruption of minors with white slavery. So those are the three problems given in the chapter on chastity. Now let's go now to the crime against honor. Ito dalawa, tapos tigisa sila, tapos dalawa until national security. So, on the crime against honor, the offense has something to do with cybercrime libel. Number 14 reads, John and Pilar were in a dating relationship for a year. But due to the abusive behavior of John, Pilar broke up with him. John pursued Pilar, but she refused to reconcile with him. He then uploaded to his social media account the video of their sexual congress, as well as the nude pictures of Pilar, all of which he had recorded on his cell phone without the knowledge of the latter. Distraught, Pilar filed a complaint with the office of the prosecutor and submitted in evidence the video and pictures that John posted on social media. What offense, if any, did John commit? Discuss. Okay, let's take a look at our suggested answer. John committed the offense of cybercrime libel for uploading in social media his sexual congress with and nude pictures of Pilar. Said media uploads dishonor Pilar. Yan, so libel yun. Now, in terms of computer-related offenses, there is such a thing as a content-related offense. And libel reads the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or any other similar means which may be devised in the future. Yan. So, yun ang tinatawag natin na cybercrime libel. Libel is a public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstances tending to cause dishonor. So any act that will dishonor a person, discredit or contempt of a natural or juridical person, or to blacken the memory of one who is dead, is libel. So when John uploaded the pictures on the social congress and the nude pictures, it was really an act of dishonoring Pilar. And so this will allow Pilar now to file a criminal case of cybercrime libel against John. Libel committed by means of writing, printing, lithography, engraving, radio, pornography, painting, theatrical exhibition, cinematographic exhibition, or any similar means. Yun, nadali na rin sa other similar means. No? Continuing. The photo, video, or video voyeurism means the act of taking photo or video coverage of a person or group of persons performing sexual act or any similar activity, or of capturing an image of the private area of a person or persons without the latter's consent, under circumstances in which such persons has or have a reasonable expectation of privacy. The act of selling, copying, reproducing, broadcasting, sharing, showing, or exhibiting the photo or video coverage or recordings of such sexual act or similar activity through VCD, DVD, internet, cellular phones, and similar means of device without the written consent of the persons involved, notwithstanding the consent to record or take photo or video coverage of the same was given by such person. So, even if pumayag na pagpalitrato, hindi kasama dun sa pagpayag na yon na i-display mo din. So, kung magka-partner kayo, di ba, sige, litratuhan natin yung sarili natin na para may souvenir tayo. Okay lang yun kung pumayag, no? Sabi ng babae, okay, sige. Pero ating dalawa lang yan, ha? Nag-away sila, nagalit ngayon, for example, si John kay Pilar, in-upload. That is already a cybercrime of libel because that is putting dishonor on Pilar by displaying yung mga sexual act nila na kinunay. Okay. So that is the crime that was the problem that was given on crime against honor. Now, on the crime against public interest, so very interesting. On the crime against public interest, what happens here is that there is a false testimony or perjury of personal data sheets. This is the last problem, number 20. Dita is a councilor of Mati City, Davao Oriental. Her staff, Arabella, alerted her that she is already delayed in the submission of her 2023 personal data sheet, an official document. Dita handed Arabella a copy of the 2022 PDS she previously filed and asked her to accomplish the 2023 PDS for her, instructing her to just copy the entries in the 2022 PDS. One of the questions in the PDS is whether the government official has a pending case before any tribunal. Arabella answered no to the question even if Dita was in fact indicted for libel, which was pending before the regional trial court. After Arabella filled out the PDS, she delivered it to Dita for review, who hastily signed and submitted it without even checking the veracity of the accomplished entries. What crime, if any, did Dita commit? Explain. Our suggested answer is Dita committed perjury in submitting her personal data sheet when she answered no as to whether she has a pending case. The truth is she has pending case for libel but failed to state the truth. Perjury is committed when a person who knowingly making untruthful statements and not offering false testimony and evidence shall testify under oath or make an affidavit upon any material matter before a competent person authorized to administer an oath in case in which the law so requires. The personal data sheet is subscribed and sworn to before the highest ranking human resource management officer an authorized official or officer of the agency, any officer authorized to administer oath, or a notary public. This is pursuant to Articles 183 and 184, Section 2 of the Revised Penal Code, and a decided case in Union Bank and Desi Tomas versus People, a 2012 decided case. So that is on public interest. We are now going to public order, and there were two problems given in public order. Let's take a look. In public order, the problem that was given has something to do with the service of sentence and evasion. Problem number 10. This one is very interesting. Noel, Omar, and Dennis were all convicted of illegal possession of drug paraphernalia and sentenced to 7 months in jail. On their third month, a typhoon caused floodwaters to rise up to 5 feet in the jail facility. Fearing for the lives of the prisoners in the facility, the jail warden released all prisoners with a directive that they should return when the storm ceases. When the storm passed, only Noel, Omar, and Dennis turned themselves in with the explanation that they would have starved if they did not return. Later, Noel, Omar, and Dennis were charged with evasion of service of sentence because they returned not to continue to serve their sentence but for fear of starving. The jail warden was likewise charged with infidelity in the custody of prisoners. Rule on the respective criminal liabilities of Noel, Omar, and Dennis, and the jail warden, if any. Our suggested answer: Noel, Omar, and Dennis are not liable for evasion of service of sentence because they did not escape during their imprisonment of final judgment. So, this escape is what is evasion of service of sentence. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any convict who shall evade service of his sentence by escaping during the term of his imprisonment by reason of final judgment. This is a decided case in 1967 involving Tanega versus Masakayan. Now, insofar as the jail warden is concerned, if there is no obligation, if there is no evasion of sentence because there is no escaping, the jail warden was not also liable for anything. Pinayagan lang niya kasi baka malunod. And that is not a violation of his duty. And the last module on crimes against persons has something to do with problems on national security. So let's take a look at these two problems. National security. This one is very ticklish, no? The offense of treason, and the problem reads, problem number 8. Samuel, a Filipino citizen of Chinese descent, assisted the Chinese government in surveying and determining the safest and most secure shores in the Philippines. He thought he was helping the Philippines in this endeavor since the geodetic maps he prepared would allegedly be transmitted to the Philippines for future use. Before the survey was completed, Chinese military vessels entered the Philippines' Scarborough shores, set up a station secured by 2 warships, and populated 2 islets which the Chinese government proclaimed as their own, all with the use of the geodetic maps. Samuel was then charged with treason by the Philippine government. The following testified against Samuel. His helper, Therese, who saw Samuel in various meetings with the Chinese government, though she did not understand their conversations since she does not know Chinese. And number 2 is Gardener Rolando, who knows Chinese but has bad eyesight. Rolando was present in all these meetings and had a glimpse of the finished geodetic maps signed by Samuel. Is Samuel liable for treason? So the simple question is, meron bang ginawang treason itong si Samuel? Our suggested answer: Samuel may not be held liable for treason because there is no war officially declared between the Philippines and China. Treason is when any person who owing allegiance to the government of the Philippines, not even a foreigner, levies war against them or adheres to their enemies, giving them aid or comfort within the Philippine Islands or elsewhere, shall be punished by reclusion perpetua to death and shall pay a fine not exceeding 20,000 pesos. No person shall be convicted of treason unless on the testimony of two witnesses attest to the same overt act or on confession of the accused in open court. So this one was not met, and the critical thing here is that there cannot be any treason if there is no declaration of war between China and the Philippines. Again, the last problem, second problem on national security, which becomes the last problem in the in criminal law in the 2023 bar examination. Problem number 9. Macario, a student activist known for his anti-government views, decided to take measures into his own hands and carried out the following activities. Number 1, he mobilized his barangay and instructed his members on the finer points of mass uprising. Number 2, he organized the People's Liberation Organization Against Poverty, PLOP, and led a march to Malacanang to air their grievances, chanting subversive words denouncing the lack of action by the government to alleviate their plight. Number 3, he divided PLOP into groups of 4 members and ordered them to commit theft, raising over 1 million pesos to finance their activities. And number 4, he posted a threat on his highly popular social media account that he will bomb several malls in Metro Manila if the government will not give in to his demands of providing temporary cash handouts to the unemployed by the end of the month. The police then arrested Macario and charged him with the violation of the Anti-Terrorism Act. Will the charge prosper? Discuss. Yes, Macario can be charged with violation of the Anti-Terrorism Act because his acts constituted acts of terrorism. Terrorism is committed by any person who within or outside the Philippines, regardless of the stage of execution, 1, engages in acts intended to cause death or serious bodily injury to any person or endangers a person's life. Second, engages in acts intended to cause extensive damage or destruction to a government or public utility. Engages in acts intended to cause extensive interference with damage or destruction to critical infrastructure. Develops, manufactures, possesses, acquires, transports, supplies or uses weapons, explosives or of biological, nuclear, radiological, or chemical weapons. And finally, under terrorism, a terrorism is committed by any person within or outside the Philippines regardless of the stage of execution, the release of dangerous substances, or causing fire, floods, and explosions. When the purpose of such act by its nature and content is to intimidate the general public or a segment thereof, create an atmosphere or spread a message of fear to provoke and influence by intimidation the government or any international organization, or seriously destabilize or destroy the fundamental political and economic and social structures of the country, or create a public emergency or seriously undermine public safety, shall be guilty of committing terrorism and shall suffer the penalty of life imprisonment without the benefit of parole and the benefits of Republic Act 10592, otherwise known as the Act amending Articles 29, 94, 97, 98, 99 of Act 1315 of the Revised Penal Code, provided that terrorism as defined in this section shall not include advocacy, protest, dissent, stipend of work, industrial or mass action, and other similar exercises of civil and political rights which are not intended to cause death or serious physical injury to a person, to endanger a person's life, or to cause a serious risk of public safety. With this long explanation, it would appear that Macario has really committed acts of terrorism and should be charged accordingly. Ladies and gentlemen, we have covered the 20 problems given in criminal law in the 2023 bar examination. And therefore, there are a lot of very interesting areas that were touched in the criminal law examination. A number of principles came out, including yung modification of the mistake of fact. Dapat merong opportunity, if there is an opportunity to verify na talagang yun ang asawa niya at hindi verify, then there is no benefit of mistake of fact. Second, yung finder-in-law. Napakagandang concept yun. Then the introduction of the new special complex crime of kidnapping for ransom with homicide. Isang ano na lang yun. Wala nang complex crime na under Article 48. And the other things that were taken up, that would have given us a beautiful orientation of what really has happened. With this, I'd like to thank you very much for allowing us to share with you this particular segment on criminal law. And while we're starting to really touch base on what we want to cover, again, let me reiterate my dedication to my friend who was unlucky to have been killed by his own cousin and never had the opportunity to take a second bar examination. Noel, I feel very sad for you because you were looking at me and you were inspired that even if I'm older, I took the pain of enrolling in the College of Law. I tried very hard to top the bar, and you were following also the things that I was doing. I was lucky, perhaps the Lord has a reason for that, to become now a lawyer, an attorney at law for the past 29 years now. Medyo sinwerte pa, naging dean pa ng College of Law. And I'm very sure you would have wanted the same. Brad, namimiss kita, nalulungkot ako na wala akong kaibigan ngayon na naging abogado na katulad mo. To the family, to the wife of Noel Innocentes and his 3 children, please accept my most sincere reiteration of my rightfulest condolences, but the way to say it is I feel very sorry, not only for myself in having lost a friend and a loyal follower like Noel, but also you have lost a husband and a father. And I know he was a very hardworking person. Kung medyo kuminsan malakas ang dating niya, parang pareho ko rin kuminsan nami-misinterpret ako. But Noel is a good man. I have been with him for quite some time. Hindi ko siya nakitaan ng masamang konsyensya. He would have been a very good lawyer had he been given a chance. With this, ladies and gentlemen, I'd like to thank you very much for allowing me to have this criminal law suggested answers for the 2023 bar examination. Marami pong salamat as I close this particular session with you. Thank you so much.